This program is brought to you by Emory University.
Director of the Center for the Interdisciplinary Study of Religion, the sponsor of today's proceedings. Our center is dedicated to studying some of the religious sources and dimensions of cardinal issues at the intersection of law, politics, and society. The center sponsors advanced research seminars, research projects, publications, courses, and various public forums, such as this one. This year's Family Forum series has been focused principally on children. From this lectern, we have addressed a number of issues ranging from the use and disposition of frozen embryos to the virtues and vices of corporal discipline for minor children to the tragedies of violence by and violence to children. Today we address some of the intricacies and intimacies of the law of statutory rape, that special category of rape law that the criminal law singles out for the protection of young women, ostensibly. Is statutory rape an essential protection of youth from their own immaturity and sexual exploitation from others, or is it a vestige of an antique paternalism that seems unusually preoccupied with the supposed virtues of virginity and chastity? Is statutory rape an offense to be prosecuted with equal vigor in all cases and with prescribed sentences? Or should we allow for a discount, a mitigation, if the minor parties in question have had prior intimacy? Or should we exculpate them altogether if it's a simple consensual relationship? These are amongst the various issues that we shall have under discussion today in our forum. Our speaker, Professor Dr. Kay Levine, is a ranking authority on this subject. Professor Levine holds both her JD and her PhD from the University of California at Berkeley, Bolt Hall. Her dissertation, completed in 2003, is entitled Prosecution, Politics, and Pregnancy: Enforcing Statutory Rape in California. She's developing this dissertation into an important new monograph and has already produced a number of important articles on this and related topics. She brings to her task not only the best of law and social science inquiry, but also practical experiences garnered as a deputy DA and a criminal defense attorney in the good state of California. I had the privilege of being at Berkeley last month and had occasion to speak with a number of Professor Levine's former professors. And many of these professors sua sponte remarked to me when they learned I was from Emory, Kay Levine was the best student I ever had. You should feel lucky to have her at Emory. Well, we feel very lucky indeed, and we feel privileged that she has graciously agreed to grace our lectern today in our Family Forum series. She will offer a 40-minute or so lecture on the intimacy discount in statutory rape cases, and then the floor thereafter will be open for questions. We'll stand adjourned promptly at 1:20 for those of you that have 1:30 classes. Will you please join me in offering a very warm welcome to our friend, to our teacher, to our colleague, Professor Dr. Kay Levine.
I usually don't get a microphone in class. This is a new experience for me. I want to say thank you very much to John Whitty and Scissor for inviting me to present here today. It's really kind of an honor, and it's a new experience for me. I've only been here at Emory for a little under 2 years, and this is really my first chance to address the community generally, instead of just imposing myself on my own students who have to sit with me a couple of hours every week. I also want to thank all of you for coming today on this particularly sunny Wednesday towards the end of the semester. I appreciate what you're giving up to be here, and I will appreciate your comments and questions at the end. I've been asked to speak to you today about my own research that involves prosecutorial discretion and statutory rape law. But before I get into the details of that, I want to sort of set up for you a broader theoretical framework within which these questions arise. While there are many open questions in the area of law, there are two things that we know for sure. The first is that disputes that implicate legal rights occur both between strangers and between people who know each other. And the second thing that we know for sure is that while the formal law broadly and technically applies, regardless of the relationships that the parties have to each other before the dispute arose, when it comes to resolving problems, those who know each other, acquaintances, friends, family members, lovers, and spouses, have a different relationship to the law than those who are strangers. But how is this relationship to the law, that is one's access to and use of the law, determined? And there are really two principal factors. The first is victim invocation. A victim invokes the law by, for example, calling the police or filing a lawsuit either on her own behalf or with the help of an attorney. The sociological and anthropological literature consistently show that those who are wronged by a relationship partner, whether somebody in a business relationship or a personal relationship, are far less likely to invoke the law than their stranger colleagues. And the more long-lasting and the more intimate the relationship, the less likely one is to turn to the formal law for help in solving relationship problems. The second factor is called system response to victim complaint. And here, by the system, I'm specifically talking in my own research about the criminal justice system, criminal justice actors, formal actors like prosecutors, judges, and juries, identify and construct the victim complaints about which they learn according to predetermined models of behavior. That is, they are inclined to separate real from technical crimes based on the perceived level of harm suffered by the victim and the perceived level of culpability manifested by the defendant. By making these assessments, criminal justice actors channel complaints differently through the criminal justice system. And most specifically, discretion exercised by these types of criminal justice actors fashion what I've termed a criminal justice discount for intimacy. That is a discount for pre-existing relationships between defendants and victims that work to benefit certain defendants. This relationship, this pre-existing relationship that generates an intimacy discount, suggests both that the victim suffered only minimal harm at the hands of the defendant and that the defendant is somehow less blameworthy for the harms that he inflicted because the victim shares some responsibility for the crime. Both of those assumptions are embedded in the intimacy discount. Criminologists have identified this discount most significantly in cases involving crimes against the person. They note its effects in filing, in conviction rates, and in sentencing outcomes. They have also suggested that the discount is most likely to take effect at the prosecutorial filing stage, given the increasing power of the prosecutor to set the terms and limits of any criminal case. My own project builds upon these quantitative empirical findings by interrogating how prosecutors construct and employ the intimacy discount, particularly in a caseload where every crime involves some measure of intimacy. That is, every crime involves a defendant and a victim who know each other, who have some level of acquaintance, and have experienced what most other scholars regard as a significant level of intimacy, and by that I mean sexual intimacy. In other words, the crime that I study is statutory rape. Before I get into how statutory rape operates, let me give you just a brief sort of legal background so I can embed it in the legal frameworks within which prosecutors in California work. Statutory rape is defined in California Penal Code section 261.5 as anyone who has unlawful sexual intercourse with a person under the age of 18 who is not one's spouse. The crime is not limited to adult defendants, and it is not limited by gender for either the defendant or the victim, although that change only happened in the early part of the 1990s. Statutory rape is a crime that is meant to serve population of teenage victims, because California has a different statute which criminalizes sexual activity of any kind, and in a broader sense, with children under the age of 14. That crime is child molestation. California also has an extensive forcible rape statute that penalizes by up to 8 years in prison anyone who forcibly subjects another person to sexual intercourse. And force in that case can either be by violence, by intoxication, taking advantage of a developmental delay, etc. So statutory rape law is meant to serve this population in the middle, that is teenagers, those over 14, who were not technically forced to have sexual intercourse with another person, either another juvenile or an adult, and yet somehow deserve the law's protection. My data reveal that California prosecutors have individually and collectively developed a set of norms to distinguish real statutory rapes from technical violations of the statutory rape law. And they've done this because the formal law, as I've just described, is broad enough to criminalize any sexual intercourse with somebody under the age of 18. That involves a lot of activities of sexual intercourse. By sorting out technical violations of the law, prosecutors offer an intimacy discount to the subset of statutory rape defendants who, according to prosecutorial criteria, seem the least criminal and therefore the most deserving of leniency. Now, before I get into my data in more detail, I want to give you a few words about how I conducted my research and also to give you some information about how statutory rape seems to have emerged on the criminal justice agenda after decades of being virtually a dead letter. As Professor Whitty mentioned, this project is part of my doctoral research, which I conducted in the late part of the 1990s and early into 2000, 2001, and 2002. I conducted interviews with government bureaucrats in California who run criminal justice policymaking, and I surveyed and interviewed prosecutors across the state in order to find out how they specifically handle statutory rape cases. My survey and interview questions were meant to ferret out how prosecutors think about their jobs, how they translate the requirements of the formal law into the realities of dealing with 100 or 100 or more cases a day, a week, or a month. Now, statutory rape made it onto the criminal justice agenda in the middle part of the 1990s. Throughout the 60s, 70s, and 80s, statutory rape went virtually unenforced, not just in California, but pretty much across the United States. Most people attribute this to the norms that went along with the sexual revolution, when women, men, teenagers, adults were encouraged to become more sexually liberated in their lifestyles. And given that norm of increasing sexual liberation, the idea of statutory rape, that is protecting teens just for the sake of protecting them, didn't seem to make much sense. But by the early part of the 1990s, this following on the heels of the late 80s, lots of people were talking about teen pregnancy and increasing welfare reliance as a major policy dilemma for the United States, and it became a policy dilemma for California in particular. And in the wake of those debates about what we should be doing to stem the tide of teen pregnancy and to stem the tide of teens who are relying on welfare earlier and earlier in their lives, there were some researchers who, for completely other reasons, began to research the demography of who were the fathers of these babies born to teenagers. One of those researchers was a graduate student at the University of California at Irvine, and his data revealed that 2/3 of the babies born to teen mothers were fathered by adults, that is, men who are over the age of 18. His data hit the airwaves like you cannot even imagine. All of a sudden, it's all that anybody in criminal justice could talk about. People who were interested in stemming the tide of teen pregnancy suddenly had a new scapegoat. Instead of blaming the girls for getting themselves pregnant, they suddenly were able to point the finger at the men for impregnating these young, impressionable girls and then leaving them behind, leaving them to a lifetime of welfare support. Now, while the data on which these policymakers originally relied was later contradicted by later studies showing that the percentage of teen fathers involved in producing babies in what would be a statutory rape context was significantly lower than that 2/3 percentage, it didn't matter. The policymakers, particularly in California, went with the first set of numbers and decided that their solution to handling their teen pregnancy welfare crisis was to reinvigorate their law of statutory rape. It had been on the books in much the same form for many decades, originating back in 1850, and they decided simply to revive the perfectly good law they already had, that is, to go after the men. This would serve deterrence purposes for those of you taking criminal law now. The theory is, if we aggressively prosecute a crime, we send a message out to everybody, men in particular, that if they impregnate a minor or if they have a sexual relationship with a minor, they too will be prosecuted and will spend a significant portion of time in jail. The second motivation was to get a lot of these men on probation or parole, which would include terms of paying child support for all of these babies that they had abandoned and refused to pay for. Additionally, the state hoped to perhaps send a message to teen girls that they could rely on prosecutors to be their best friends, to help them collect the child support which they were having so much difficulty collecting on their own. Now, the teen pregnancy welfare story was the original animating rationale for California's development of a very aggressive statutory rape enforcement program in 1995. The program was the brainchild of Governor Pete Wilson and a couple of bureaucrats who worked beneath him. And the program was called the Statutory Rape Vertical Prosecution Program. California's idea was to give money directly to prosecutors to develop specialized enforcement teams within each of the 58 county DA's offices that already existed. California had a history of doing vertical prosecution for very serious crimes that involve crimes that involve sensitive treatment of victims, like domestic violence, career criminal cases, homicide cases, etc. Using it for statutory rape was a completely new idea, but they decided to draw on the successes of their past vertical prosecution programs and inspire prosecutors to take a much more serious and hardline approach to prosecuting statutory rape. The program got underway in a pilot project with 16 counties in 1995-96, and in 1996 it was expanded statewide so that every county in California had the option to take money from the state to develop a specialized prosecution unit. And for the bulk of the life of this program, 54, 55, or 56 of the 58 counties took that money. The money ranged from anywhere from $50,000 to the small rural counties to over $300,000 for counties like Los Angeles or Alameda. And each year, California spent more than $8 million on its statutory rape program. So that means that over the 7 or 8 years when this program was actively running, the state of California spent more money on statutory rape prosecutions than on domestic violence prosecutions, child molestation prosecutions, career criminal prosecutions, grand theft auto, etc. All of the other vertical prosecution programs that California had previously run had never been expanded statewide. They remained consistently competitive, and money was distributed only to a few counties. The statutory rape program is the only program California decided to take statewide and to fund at that level. Now, after a few years of operation under the teen pregnancy welfare rationale, thousands of mostly men were being prosecuted for statutory rape, prosecuted, convicted, and serving jail time. But after a few years of running on the teen pregnancy welfare rationale, California prosecutors and bureaucrats in Sacramento decided that that was no longer an operable policy. And they reached this conclusion for a number of reasons, which I will address during the question and answer session. But the short version is they became very concerned about underserving a significant population of victims, and that is those victims who were not impregnated or abandoned by their partners, that is, left to raise a child on their own. These victims, those who were not impregnated or left to raise a child on their own by partners, included both girls who had been the victims of other forms of exploitation, as well as teens who were involved in same-sex relationships. So in 1999, now under the directorship of Governor Gray Davis, who was a Democrat in contrast to Pete Wilson's Republican stance, the program took a different turn. It was inconceivable that the program would be disbanded because lots of money had been spent and lots of people had been hired in order to make it go forward. So the program simply had to shift direction. And the rationale that they adopted in 1999 is known as the exploitation rationale. That is, defining statutory rape as a form of sexual exploitation of teenagers. And here, I mean the immaturity and inexperience that characterize the teenage years make teenagers vulnerable to exploitation by adults. So under this theory, exploitation means adults who, through the use of economics, deceit, violence, intoxication, or romance, cajole inexperienced and immature youth into participating in sexual acts for which the youth cannot possibly consent and whose consequences the youth cannot possibly understand. Now, the interesting thing about the exploitation framework is not that it emerged at all. It certainly drew upon lots of other discourses we were seeing in the late 1990s about sexual predators, about sexual abuse by priests, about sexual offender services, sex offender registration services, etc. But the exploitation paradigm has a twin, and that twin is intimacy. That is, once we identify at the far end of the spectrum of statutory rapists, those who are exploiters, those who take advantage of victims by abusing positions of trust or intoxicating teenagers in order to get them to have sex, we start to see the emergence of a different set of statutory rapists at the other end of the spectrum. And those are the intimate statutory rapists, who I sort of loosely define as peer defendants. And the intimate caseload reflects the sort of opposite paradigm of the exploitation caseload. That is, intimacy connotes understanding, caring, and sacrifice between co-equals in the context of a romantic sexual partnership. This means that the adult does not exploit the teenager to get sex, but rather sex is an organic part of an already healthy relationship that causes no harm to either the teen or society. So based on this spectrum, which emerged in prosecutor discourse, both individually and collectively through statewide meetings, prosecutors began to distinguish treatment within the bounds of one formal law. They began to distinguish how to treat predators, that is the exploiters, differently from peers, and how to handle everybody else in between. And this paradigm, this predator-peer distinction, rested largely on prosecutorial constructions of power differentials, age differentials, and relationship status. Now, predators and peers don't represent all defendants in the statutory rape caseload. They rather serve as two ends, that is, the extremes of the caseload. And predators receive, those who are labeled predators, receive the full force of the criminal law at every stage of the prosecution, while peers receive leniency every chance they get. So let me say a little bit about what connotes the predator and what connotes the peer. Predators tend to be defined based on their behavior, their status, or the outcome of the sexual activity. And by behavior, I mean things like adults who have sex with multiple teenagers within a short period of time, people who are perceived as taking advantage of teens and then moving on to the next one as soon as the sexual novelty wears off. I mean, adults who intoxicate or offer drugs or alcohol to youth as a way to get them to have sex. Adults who ask youth to become involved with them in their own criminal enterprises. Those are the sort of behavior categories. The status categories involve adults who are significantly older than the teens with which they have sex. And by significantly older, I mean more than 10 years, more than 20 years, more than 30, sometimes even more than 40 years older. There are plenty of cases, it's sad to say, of 62-year-old men hanging around the middle school waiting for their next conquest. Those are the people who definitely fall into the predation category. Also in the status category, we have people who are ex-cons, who are seen as sort of generally just bad guys, people who are currently on probation or parole for other violent crimes. And then lastly, the outcome category involves defendants who do not adequately protect their intimate partners either during sex or after. That is, defendants who transmit STDs or HIV to a sexual partner, defendants who impregnate a partner and then abandon her, leaving her to rely on welfare. So the sort of outcome determinant factors also identify predators in the California caseload. In contrast, peers are defendants who are close in age to their sexual partners, who manifest relationship stability, that is, they have sort of signs of commitment and permanency, a relationship that looks to prosecutors like it might lead to marriage. And lastly, the relationship receives the support of the defendant and victim's family and oftentimes community. So in a lot of these cases, there is evidence of a cultural marriage that was performed before the defendant and victim came to the United States or after they were recently arrived. That is a common claim among defendants from immigrant communities. So how does this distinction get operationalized? Once prosecutors identify these abstract categories of predators and peers, what exactly do they do with it? And what I discovered from spending extensive hours talking to DAs was that prosecutors employ what I call instrumental filing. They decide what they want to happen to a defendant right at the outset and then file the case accordingly. And in order to make that decision, in order to make that call about what should happen to the defendant, they need to conduct extensive pre-filing investigations. That is, they spend a lot of time talking to the victim, her friends, her family, her teachers, her medical professionals. They may talk to the defendant and his friends in order to get a vast and sort of nuanced sense of this relationship and the likelihood that it will last long into the future. So by doing instrumental filing, by deciding at the outset what they think this defendant deserves, state prison, a year in jail, some amount of probation or something less, perhaps diversion out of the system if he successfully completes a series of classes and educational programs. By deciding at the outset what they want defendants to get and then filing accordingly, picking which crimes will get them to that result, instrumental filing and the intimacy discount serve as a self-fulfilling prophecy because prosecutors currently wield almost total control over the statutory rape caseload. That is mostly because, like other crimes in the criminal justice system these days, statutory rapes are far more inclined to end in a guilty plea than in trial. But in the statutory rape caseload, that percentage of cases that end in guilty pleas is somewhere around 99%. And that means that prosecutors, by determining what charges they file, determine what charges the defendant will plead guilty to. There's almost never a factual dispute in these cases, and most defendants confess because they are so happy not to be being charged with forcible rape. They readily admit a consensual sexual crime. So the intimacy discount really takes effect in two ways through instrumental filing. One is that prosecutors file fewer charges overall. They don't engage in what one prosecutor referred to as unnecessary dogpiling. They don't simply amass counts in the complaint to have a longer charging document. They pick the crimes they want the defendant to plead guilty to. Additionally, instrumental filing using the intimacy discount means that prosecutors in most jurisdictions reserve felonies and state prison qualified felonies only for some of their most serious offenders. They don't subject peer defendants or defendants on the lower end of the spectrum to the possibility of prison exposure. I want to spend the last part of the talk discussing some of the implications of the use of the intimacy discount as I found it. And there are really two that I'd like to focus on. The first is prosecutors' invocation of what seems to me to be an outmoded sexuality norm. And the second one is prosecutors' use of discretion to mask the full reach of the statutory rape law in its current form. So let me address the first one first. The sexuality norm implications. Now, as I spent time talking with prosecutors and collected their interview data and transcripts, it became very clear to me that prosecutors were deciding the intimacy discount based on their assessment of stable, permanent relationships. That is, they decided that peer defendants were those who were having sex within the context of a stable, permanent relationship, one that is likely to lead to marriage and to provide a sort of supporting, loving relationship for the teen for a long time to come. And let me just give you some examples of prosecutors speaking about that. It's a situation where the participants have shown a permanency. They have shown a real desire to be together. They have held themselves out as people who are in a permanent relationship. That from a prosecutor from Hazel County, December 27th, 2001. Another prosecutor says, for instance, if the parties come in and say they are going to get married, if they come and actually show us and follow through with that, that can be cause for leniency. Where it is not advisable or for other reasons where marriage really isn't something that can be foreseen, then the party takes responsibility financially. That's something else we try to encourage. If somebody is willing to step up and be responsible, then we won't make the law go against them on that. And that from the prosecutor from Franks County, October 29th, 2001. Other prosecutors mentioned specifics, the things that they're looking for. Is the defendant paying child support? Is he being a responsible parent? Is the teenager still in school? Is the teenager getting good grades? Does the teenager and the defendant, do they share a joint checking account? Has the defendant made promises to be around in the future? Does he seem like a decent guy? Does he seem supportive of her individual educational and professional goals, etc.? Now, I'm not arguing that the ascription of peer status to defendants and victims who engage in a sexual relationship in that context is detrimental to the defendants who win that status. I think it actually comports with a lot of our common sense notions about who seems to be the least criminal in the statutory rape caseload. My concern with prosecutors' invocation of terms like permanency, commitment, and responsibility is that it seems to be under-inclusive in terms of separating out who the non-exploiters are in the statutory rape caseload. And by this I mean, it seems to me that there are ways for teenagers and adults to have sex that is fully non-exploitative and yet also not set within the boundaries of a loving, committed relationship. Now, prosecutors, by invoking this norm of permanency, commitment, responsibility, and sort of loving relationships, seem to me to be invoking an outmoded sexuality norm that used to identify appropriate sex with engagement sex or marital sex. And now at least many segments of the population have expanded their understanding of what constitutes appropriate sex in some settings to include something more akin to recreational sex, decided between two people who are fully willing to participate. Now, by deciding that only defendants and victims who engage in sex in the far right end of the spectrum, that is the permanent, loving, committed relationship, prosecutors are deciding that really all other forms of sex constitute criminal sex. That is, the requirements of the formal law apply to all of those other defendants and victims, and pretty much not to the defendants who are classified as peer defendants. And now the point here that I want to make is not so much that it's our job to figure out who the worst of the worst are or where these fine divisions are, but rather that we should take seriously, in a law that allows for such broad application, the differences between deciding that something is a bad idea, something that we would hope our own children would not engage in or their friends would not engage in, or we would be sad to learn our friends engaging in, but rather, is this something somebody deserves to go to prison for? And I say that very specifically because a 19-year-old who is romantically involved with a 16-year-old in a sexual way could go to prison for 3 years for that encounter or that relationship if he or she does not get peer status. 3 years in prison. So these differences really matter. It's not just a difference in abstract categories about who is what. The defendants who don't get the benefit of peer status face 3 and sometimes 4 years in prison. It also seems to me that prosecutors are applying upper middle class ideals about when sex is a good idea to the populations that they prosecute, many of whom are from minority groups and immigrant groups, working class and lower classes generally. They use their own sense of about when sex is appropriate and apply those norms to groups which may not have the benefit of as many choices as prosecutors did in their own lives. Now, it seems to me that this stingy ascription of peer status affects not only the offenders who don't get it, that is, the 19-year-olds who may face a 3-year prison term for not getting peer status, but also leads to a somewhat stingy treatment of victims. It signals to the victims that it's only okay to have sex if you're in a loving, committed relationship. Those victims who want to, those teenagers who want to have sex outside the boundaries of a loving, committed relationship are declared incompetent in the words of the formal law. So the intimacy discount credits a victim's competency to make a decision about sex if she's in a stable, committed relationship. But it denies the intimacy discount to her partner and denies her that ascription of competency, even in facts that don't involve actual exploitation, simply because the relationship is lacking. And it seems to me, then, that what prosecutors are doing are making decisions about relationship status rather than the facts of actual exploitation. Why is that troubling? Because it's the exploitation scenario which currently animates the entire statutory rape enforcement program. That is the purpose for the program. So if prosecutors cannot articulate facts supporting a claim of actual exploitation in many of these cases to which they are not ascribing the peer discount, the program is internally inconsistent. So the second implication I want to talk about concerns prosecutorial discretion more generally, and the intimacy discount is simply used as a case study here. Discounting for intimacy, like prosecutorial discretion more generally, channels weak cases out of the system. That is, prosecutors decide early on who deserves to suffer the full wrath of the criminal justice system, who deserves full litigation, the sort of full court press, and who merits lenient treatment, who can get weeded out early on by being offered a very lenient disposition in order to plead guilty. So that means that sympathetic cases are disposed of quickly and quietly. And prosecutors often deny their existence at all in this caseload. If you ask prosecutors who is getting involved, who's getting caught up in the statutory rape enforcement web, they focus on the predators and are inclined never to mention the peer cases at all, even those who have peer cases in the stack of files on their desk. Now, on the one hand, the weeding out of weak cases is good for defendants. It's good for prosecutors and good for the system. It's good for defendants because defendants who don't deserve to have the full force of the criminal justice system brought down on them can escape early with minimal sanctions. It's good for prosecutors. It shows that they are not just a criminal justice mill, that they are sensitive to the needs of defendants, that they understand the restrictions posed by constrained resources. And it's good for the system because it helps the system run more efficiently and means that everybody is focusing their resources on the defendants who most deserve it. So deserving defendants get leniency, prosecutors wisely reserve resources only for their serious cases, and the courts run in a more expedient fashion. But the problem with weeding weak cases out of the system, that is filing them first and then weeding them out of the system, is that it keeps hidden from public view the full reach of what many consider to be a controversial and overly broad law. If we file these cases and then dispose of them by early guilty pleas, the public never receives information about the formal law's applicability to those kinds of cases. Those cases don't go to trial, they don't get reported in the press. Most people have no idea that they go on at all, which means they have no idea that the formal law is so broad as to technically criminalize that conduct. So there's no cause for public debate over the breadth of the law's provisions. Why is this a problem? To me, it seems that we ultimately then ensure the longevity of the formal law because we never let the public in on the secret that the statutory rape law criminalizes thousands and thousands of instances of sexual intercourse every single day or every single week. We instead remind the public that prosecutors are going after the 62-year-old men who are hanging outside around the middle school, or the teacher who is taking sexual advantage of a student, or the coach who's taking sexual advantage of a player, or the priest, or the intoxicator, or the multiple victimizer, any of your other behavioral categories. We never tell the public that lots of other forms of statutory rape are technically criminalized. So it seems to me we are ultimately ensuring the longevity of this law, despite its controversial and overly broad nature, and despite the fact that there seems to me to be at least a question about whether there is any longer a moral consensus about setting the age of consent at 18 or applying it in such a broad fashion. So in sum, the prosecutorial construction and deployment of intimacy masks the true reach of the criminal law. These practices prevent the law from becoming intolerable, but they also prevent us from recognizing that the law may already be intolerable in its formal fashion. In keeping sympathetic cases out of the public domain, these forms of discretion virtually guarantee that controversial, overbroad, or outdated laws long overstay their claims to legitimacy. Thank you.
Well, that was terrific. Thank you very much, Professor Levine. I think she deserves another round of applause. Well, a marvelous set of issues on the table now for our discussion together. I would like to move to Q&A, and we have two rules of the House. Rule number one is please use the microphones halfway up in the audience in the middle aisle and speak directly into the microphone so that we can get all your good words on tape. Secondly, please abide by my rule, that is, brevity is the soul of wit and the insistence of witty. Please be brief, please be profound, and please be respectful. These are difficult issues, and please take that into account in putting your question. If you are speaking for more than a minute, you run the risk of me jumping down the aisle and tackling you. Please put your questions to Ms. Levine.
First of all, thank you very much. Your speech was enlightening. My problem with the statutory rape is the name statutory rape. When I think about rape, I think of one of the most heinous, horrific crimes somebody could commit against somebody else. And statutory rape, to me, is a sector or a part of rape, that horrific, heinous crime. And when we find ourselves having two 17-year-olds having casual sex with what you talked about, no intimacy or what this topic was faced with, both of these 17-year-olds are committing statutory rape. And no matter if they're punished with jail time or not, for their entire lives, they are statutory rapists. And I think that if we change the name for these crimes that didn't involve 62-year-olds with 16-year-olds, to change the name to encompass something that wasn't so bad and so, I mean, the median age for sex is 16 and a half. So if everyone 16 and a half was having sex in California, they would be statutory rapists. And for me, it's just that the name, statutory rapist, which will live with you forever and will limit you forever. And I was wondering if you could respond to that implication of the name and how it's not as severe, or as, in my opinion, 2 17-year-olds is not having as severe as rape entails.
Thanks, Josh. I would be happy to. Well, my first comment is that California has addressed that problem by changing the name of its statute. So to the extent that this is just a rhetorical ploy, and it might in fact be, your point is well taken, but in California, the term statutory rape is really a colloquialism. It's not the formal name of the crime. The crime is unlawful sexual intercourse. What prosecutors found as they began to work these cases was that there was a lot of resistance, not so much from defendants, but from victims to the label statutory rape. They really resented it. They said, I wasn't raped. I completely wanted to have sex with him. I love him. He took me to McDonald's last night. I think he's great. The victims really, more so than the defendants, really resisted the label of rape. And so prosecutors have tried to work into their discourse the wording unlawful sexual intercourse, because they believe that it sort of pacifies the victim. She doesn't have to think of herself as a rape victim. As far as defendants go, they mostly are concerned with trying to stay out of jail. And what shows up on your rap sheet is the code section and unlawful sexual intercourse. But your point is, in terms of who is getting swept up in this net, incredibly well taken. In California, those 2 17-year-olds could each be prosecuted for statutory rape, for unlawful sexual intercourse. Each one of them could. The empirical reality is that the state of California does not allocate any of its funds in this special program to support juvenile prosecutions, which means that very few juvies will in fact get prosecuted for statutory rape. And in my experience, the only juvie prosecutions for statutory rape were those where it really looked a lot like a forcible rape and there was going to be a problem proving force. But that being said, you're absolutely right that the breadth of this law subjects a lot of people to criminal justice sanction and lifetime stigma for behavior that many of us think back to having engaged in ourselves. Many of the prosecutors admitted this. They said, I find it ironic that I'm prosecuting people for doing what I myself was doing 20 years ago. But that's their charge. And so this is one of the things we need to think about as we draft criminal statutes in particular. The desire to make things as broad as possible to send a strong deterrent message is critical. And yet that means that we are always going to have issues about differential enforcement, because nobody really is willing to enforce this law to the full extent that it would be allowed. That would be intolerable. So we're always going to have debates and to a certain extent, so dilemmas about, well then, just who's going to fall within and who's going to get the benefit of leniency. Thanks.
Hello, Professor.
Hi, Kay.
I'm going to ask you a very narrow question based on a statement and a hypo you made. Say you have a 16-year-old, very mature-looking young woman, and she has an interest in a 19, 20-year-old guy, and she actively pursues this guy, and they engage in consensual sex. And her parents or she brings a case against him for statutory rape. The law is very clear that the guy will have some form of punishment, but what is your view on the punishment of the woman? Because it seems to be an unfair burden on the guy, especially in this scenario where she actively went out to seek him. So what is your view on that?
Well, California is one of the few states that does recognize reasonable mistake of age as a defense to statutory rape. It doesn't recognize that as a defense to child molestation. So as the child gets younger and younger, the courts are less willing to forgive claims to reasonable mistake. So assuming that we have a defendant here who could not mount a successful defense of reasonable mistake of age, he knew full well what her age was. He went to her birthday party, for example, or picked her up outside of school. So he knew exactly how old she was. That defendant is going to face some measure of the criminal justice system. Depending on what county he's in, that case could get filed as a felony, and he could be facing prison time. In fact, there was one county where the prosecutor declared himself to be a born-again Christian who said he was using this as a platform to get rid of premarital sex altogether. And so anybody he was filing a felony on, he wanted to send to state prison, and that meant 50% of his caseload. So the 19-year-old in that county would be facing state prison, even though the victim aggressively pursued him. There is technically no liability for the victim in the scenario that you described. She has technically done nothing wrong, because we, as a society, in terms of the way we've drafted this law, vest all responsibility in the adult to desist from having any kind of sexual contact with people under the age of 18. That is how we've described it. Should this 16-year-old turn around and pursue a 15-year-old, she may well find herself in trouble. But if she pursues a 19-year-old, she is technically not responsible for anything. That being said, if her parents support this relationship, if her parents get them motel rooms or allow him to live in their house, the parents can and have been prosecuted as accessories to statutory rape. They have been prosecuted for contributing to the delinquency of a minor, both of which are misdemeanors that subject them to 6 months in jail.
Hi, Professor.
Hi.
I have a two-part, but I'll be very brief. In terms of the people among the peer group and also those who are really close in age, the 16 and 19-year-old, I'm assuming that it's the parents of the minor who are reporting these cases. And if that is the case, do you see a higher number of parental reporting when it's a same-sex couple and they disapprove, of the child's sexuality? And the second question is, have you seen any research where all this money, we talked about $8 million a year going to the statutory rape criminal law. Have you seen any research that this money could be better spent in other areas, social programs, same education in the schools about safe sex, et cetera, to avoid the pregnancy, since that was the impetus for the, how do we describe it, the really enforcing the rape law?
Mm-hmm. Okay, so Nate, as to your first question, where are these cases coming from? When the program got underway in 1995, 1996, 1997, the way prosecutors found cases, because nobody was walking through their door, the way they found cases was to go to their county welfare agencies. And in most counties in California, the Welfare Bureau is connected to the DA's office. So child support prosecutions are mounted by a subsection of the DA's office. So they went to their family support division and said, give us all your cases involving teenagers. And from that, they derived thousands of potential prosecutions. And it was only after trying to get the victims to come in and agree to paternity testing of the children that they had delivered did prosecutors realize that was not really a viable option. Many of those victims were completely unwilling to participate. The statute of limitations had run on a lot of the crimes. If the child was already 4 or 5 years old, the statute of limitations had run. And prosecutors felt that that was just way too much work, trying to work up old cases. So once they turned to the exploitation rationale and sort of an emerging out of the teen pregnancy rationale, prosecutors mounted an effort in the state legislature to change the mandatory reporting law, which applies to all adults who work in a professional capacity with children, that is, health professionals, teachers, counselors, et cetera. And they became mandatory reporters of suspected statutory rape, at least in the most serious cases. So actually, a lot of the cases get reported not so much by the victim or the victim's family, but by school counselors who hear reports and then have to turn over information, who notice that a 15-year-old is suddenly pregnant and pursue a sort of internal investigation, et cetera. So while there are certainly cases involving victims who go to the police themselves, and usually those teens are not those who are considered to be acting purely objectively or purely rationally, but rather they are mad because their boyfriend is now dating their best friend. And they now have a motivation to turn him in, whereas before he was sort of everything to them. And you certainly do have plenty of cases where parents report because they don't like the fact that their child has become sexually active, or they don't like this particular partner. But just as often, if not more so, you have parents who are completely hostile to the prosecution, who think that this adult in their child's life is the best thing that has ever happened to her. These are parents who tend to have some parenting issues themselves, who perhaps have been involved in the juvenile courts and in foster care, et cetera, but who find themselves unable to take care of usually their teenage daughters and are thrilled that some other adult has come along and is willing to take on some of the burden. It's hard for me to say anything really conclusively about the same-sex cases. They have become part of the caseload. In the same-sex cases, we use slightly different statutes because the unlawful sexual intercourse specifically involves vaginal intercourse, and we have other statutes that apply to oral copulation, sodomy, digital penetration, et cetera, with a minor. But only in the last couple of years did California start collecting any data on its same-sex prosecutions. So, for example, in the early years of this millennium, they just started collecting data on gender disparities as well, that is female defendants and male victims. And then it was about 4% of the caseload that involved female defendants and male victims. The percentage of the caseload that involved same-sex couples, less than 1% in most places. And only in 1 or 2 urban counties did any prosecutors reveal that the percentage of same-sex cases in their caseload was higher than the percentage of cases involving female defendants and male victims. So there's just such a small number, it's really hard to say. One issue that seems to arise in the same-sex cases, though, is an assertion of a defense of a common introduction into the gay community is by an adult partner, that very few questioning teens come together and experiment themselves in a way that leads to a prosecution. Often there is an adult who kind of inducts a teenager into the larger community. That defense falls on deaf ears. Prosecutors believe that that is just as exploitative as the heterosexual context. And then your last question involved, is there some better use of this money? Absolutely, in my view, and that is part of my larger project. Not that it's been, I can't say that that was something that I studied in particular, but there are lots of small pilot projects around that suggest the money would be better spent if our goals are to foster the self-esteem of teenagers, if our goals are to increase the opportunities of teenagers so that they don't end up in dead-end relationships when they're 15 or 16 years old, that they're spending money in after-school programs, in job training, in teaching particularly teenage girls that their world is much broader than this little town that they live in. There are many pilot projects which support that kind of conclusion. Unfortunately, when this program was sort of going full steam, they didn't really care, and there was no empirical data required by the legislature each year in order to justify this program. All they wanted to see was the pure numbers of cases that were being prosecuted without any correlation to the goals that were announced by the program. Prosecutors like to claim that the decline in teen birth rates that California experienced throughout the 1990s is directly attributable to this program. That is an assumption that cannot be supported empirically. We just don't know. But they like to claim it anyway and say that so the money is well spent.
My question is, you earlier said that the intimacy discount caused a lack of sort of publicized cases where the majority of people would not support the prosecution, which allows the perpetuation of this law, which is in many ways controversial. Mm-hmm. But at the point where you also said that there are people who engage in sort of consensual sex, which is not exploitative, but at the same time isn't in the context of a relationship, and these people are being prosecuted. If that is something that is controversial and is something that doesn't fit in with the sort of upper-class norms that you talked about earlier, then why aren't those giving the impetus to reform the controversial law?
That's an excellent question. Those cases don't get reported in the press either. And most prosecutors really deny even that they're prosecuting those. They spend a lot of time emphasizing the really bad predators in the caseload and spend very little time talking about people who don't fit that paradigm. And all those defendants, the sort of average 21-year-old who's involved with a 16-year-old, they are all pleading guilty quite early on. And so those cases don't go to trial. Reporters never find out about them. And so the public is not really aware of them either. I think that that contributes to the larger overall problem that the intimacy discount sort of represents, that by allowing prosecutors to pick and choose which of the cases that fit within the broad formal law paradigm they want to press and publicize, that is the impression that's left with the public about the scope of the law in general. And it is a faulty impression.
In class, we always discuss where the law is and do we think that it should lead society or it should follow. In taking into consideration the recreational sex that has now become a part of our culture, do you think that there will be a third category that prosecutors will start labeling or putting cases into? And my other question / comment is, Because we know now that society as a whole has moved towards marriage later in life, how can there still be a logical group or category of intimacy for teenagers when we know that they're not getting married in those years? So how do they rationalize that category?
Two very good questions. Let me take the second one first. Not only do we know that teenagers tend not to get married in their teenage years, most prosecutors don't want them to be actually married as a sort of solution to this problem. That was a solution that some people devised in the early 1990s as a way to get rid of these child support problems, was just to marry the victims off to their statutory rapists. That didn't go over so well when it hit the press. And a big part of this program was proving that that is not what we're about. We're not about holding the shotgun at weddings. We don't really want that. But do I think that that prosecutors are inclined to start developing a sort of third category to recognize these gradations of intimacy? I'd like to say yes. I saw some inklings of it in the more sort of sophisticated urban counties that have high crime rates. I don't think it's so much that those prosecutors are more sophisticated or more sensitive. It's just that they have so much more really bad crime that they don't have quite as much of a gut desire to really go after the statutory rapists in the same way that you see in some of the suburban or rural jurisdictions. But generally, prosecutors tend to be a fairly conservative bunch and to speak to the conservative interests in society. And now I think we've been now going through so many years, almost a decade, of sexual abuse by priests, sexual predators out there, polycloths, and sex offender registries, and all this sort of talk about people doing terrible things sexually to kids. It seems almost politically untenable for prosecutors to kind of take a stand to say, you know, actually, we recognize that some of them really aren't so bad. The peer intimacy discount operates almost in secret. So if they were to take a sort of broader stand, I think that they would probably be called to task for it. That being said, even though California is prosecuting about 2,500 people a year under this program, that's up from about 200 from the early 1990s. You couldn't even imagine a district attorney getting elected or losing an election because of his particular stance on statutory rape. It's such a small percentage of any one office's caseload that there probably isn't much risk one way or the other. Thanks.
Hi. One observation and then two questions from an outsider perspective, really. The first observation, up until 2003, the United Kingdom law on this same sort of area had what's called a young man's defence, which is a very specific statutory defence to any charge, which only worked if the defendant was under 25, was reasonably mistaken as to the age of the girl, and interestingly, had never been charged or investigated for a similar offence. So it feels to me that what we achieve by statute is very much the same sort of paradigm as you were seeing working out in California. The specific queries, the UK adopted the language of USI back in 1967, and that was interpreted to exclude married sexual intercourse. Mm-hmm. So that if there was a foreign marriage recognised in English law below the age of consent, it would not be covered. And I wondered if that was the case in California.
You're asking a foreign marriage that is legal or just cultural?
Legal.
Legal marriage is a defense to statutory rape in California.
Right, that's interesting. And the second one, within the European context, the British have the highest age of consent at 16 for all genders and all sexualities. And obviously our European partners explain that very high age in terms of our approach towards sexuality. And other of our partners go as low as 12 or 13 for various combinations. I wondered why 18 in the United States? It seems very high to me. Is it that it would be politically impossible to change it to a lower age?
That's a good question, and it's one I've given quite a lot of thought to. Each of the states sets its own age of consent, and they have varied throughout time. In the 1800s, in most states, the age of consent was like 7 or 8 or 10. And it was only through the results of some sort of prototype feminist reformers that the age of consents were raised as a way to eradicate the sexual double standard. So California actually went to 18 in 1911 and has not ever reevaluated whether 18 is the right age for them. In the United States, the current ages of consent range from 14 to 18, and California is not an outlier at 18. It's certainly in the minority, but it's not a statistical outlier. The vast majority of states cluster at 15 or 16, and then there are really just a handful at the far edges. Is it a political impossibility? I would like to say no, but my more realistic side says, yeah, it probably is. I think in this environment that we're in currently, that's very sort of hyper law and order and protect children at all costs, it's hard for me to believe that California would repeal its statutory rape law or cut it back in any significant way. What I suggest we really should be doing is devising a new statute that addresses sexual exploitation in particular and requires prosecutors to plead and prove these facts of exploitation, which they regularly identify in these cases. And over time, that statute would supplant the use of the statutory rape law in all but the most sort of bizarre cases. So far, I haven't made much headway.
Thank you.
Thank you.
Hi, I was wondering if in your research you had run across any other areas in which you felt prosecutorial discretion was a horrible failure in achieving fairness.
Well, let me correct something. I couldn't say that prosecutorial discretion is horrible in achieving fairness. I do actually believe that most prosecutors in this caseload take very seriously a commitment to substantive justice as they define it. And they do, with the exception, I think, of the born-again prosecutor who wants them all to go to prison. Most of them really feel like it's appropriate to tailor a disposition based on the facts of the case and the levels of culpability that they perceive. And most of the time, I think, the use of the intimacy discount is perfectly honorable. It is their way of showing mercy or showing leniency to defendants who really seem like they got caught up in something they didn't deserve. Where I think that prosecutorial discretion is dangerous, though, is in my sort of larger point about shielding the full reach of the criminal law. And I do think that we could see that in other areas, particularly areas that stem from what we would think of as morals regulation or sort of public order regulation, where the statutes tend to be drafted very, very broadly in a way that would be most of us would consider intolerable if they were enforced to their full extent. And so prosecutors are left, police and prosecutors are left with the discretion to decide who to apply the terms of that statute to. So there has been some work in the area of vagrancy. There's been some work in the area of prostitution and other sort of public morals offenses. I think if we looked, we could probably find it in gambling prosecutions. Other things which, at one time or another were based on a sense of like a moral consensus in society that these are bad things. In all of these cases, I think that moral consensus has broken down to some degree or another. And so prosecutors have had to develop these alternative rationales to keep their programs going. So with statutory rape, we start in the mid-90s with teen pregnancy and welfare. We now move to sexual exploitation. In the vagrancy context, we're seeing those statutes being used to stop gangs and graffiti. Prostitution, we're seeing pitches about community deterioration rather than the morals about transactional sex. So I think in a lot of cases involving morals legislation, you could find similar patterns. Thank you.
Hi. It seems to me, based on what you're saying, that the hand of the law falls down harder on the lower classes in this regard. And to the extent to which that may correlate with minorities, I'm wondering if you could speak to the racial implications of this and whether it's been questioned along those lines.
It is a really good question. I think it would be foolish to say that the incidence of statutory rape is limited to people of the lower classes or non-Caucasian ethnicities. Certainly, there's just as much sex going on in the backseat of cars or behind high schools or at parties or whatnot among people from all walks of life. The reason, particularly under the original rationale of this program, that the lower classes got swept up quicker was the welfare rationale. A young woman made her pregnancy a public event, or her childbearing or child rearing a public event because she sought the assistance of a government agency. Girls that came from families that had more financial supports never had to do that, and their pregnancies remained largely hidden. They also seem to have more resources to fight child support battles on their own, as opposed to relying on the DAs to help them out with it. In terms of the link between the lower classes and minority populations, early on, this program while the program was running in California, there were some newspaper reporters who picked up on the fact that a lot of these defendants seemed to be Latino. A lot of them, consistently more than their representation in the population. And in fact, my own numbers bear that out, that more than 50% of the defendants in this caseload are Latinos. Does that signal racial prejudice by police officers or prosecutors? Maybe, maybe not. There are some consistently articulated reasons why the incidence of statutory rape might actually be higher in the Latino community than among Caucasians or non-Hispanic Caucasians, and that is the cultural marriage issue, or the sort of the cultural norm in many of the Latin American countries that send immigrants to California, that older men pair with younger teens in a way that everybody considers acceptable. So the criminal law in the United States is starting from like 3 steps back in trying to educate those communities about what's appropriate and acceptable, and they're not doing a very good job of it. And in terms of real-world prejudices that work, immigrant defendants often have difficulty with the English language that non-immigrant defendants don't experience. And defendants who do not articulate well with police often find themselves in more trouble than defendants who are more articulate. They may face more complicated bail hearings, particularly if they are not citizens. There's no way that that person is ever going to get released back into the community, and are less likely to be able to sort of demonstrate the strong community contacts that non-Hispanic Caucasians have been able to manifest. In terms of the peer discount, however, I did find that a lot of the Latino cases ended up in the peer discount category, in the intimacy discount category. So there didn't seem to be a racial prejudice in how that category was being applied. The prosecutors seemed to articulate these factors of the permanency, the commitment, the support of the family, had there been a cultural marriage somewhere else, et cetera, in a way that could apply equally to people from different races, and in fact, in some cases, would benefit the Latino community in a way that the African Americans and the Caucasians couldn't really draw on. But that being said, I think that whenever we talk about prosecutorial discretion or police discretion, we have to be cognizant of the very real possibility of prosecutors who tend, in general, to be Caucasian, middle class, well-educated, looking very different demographically from the populations they prosecute, and not really understanding how their behaviors get translated in subsections of the community. And we should be worried about discretion authorizing prosecutors to do things under the color of law which really offend our public policies. Thank you. Okay.
You spoke earlier about if a third party were to bring a statutory rape case, parents could be prosecuted as facilitators of that relationship. And I'm wondering how legislators or prosecutors reconcile the inconsistent messages they're sending about parental consent when in areas like reproductive rights and abortion law, parents are looked to as the final word for minors who want to get abortions in many states. And how is it that they can serve to speak on behalf of their minors in that area of legislated sexuality when they're not able to do that in sexual relationships that they might approve of and facilitate?
That's a great question, and you'd be surprised how few prosecutors even worry about those kinds of inconsistencies. They just don't. They operate in criminal courts. They don't operate in family courts. They don't operate in the sort of a judicial bypass proceeding. So they tend not to think across boundaries very much. But what you do hear a lot is parents cannot give permission to break the law. Parents cannot give their children permission to drink if they're underage. Parents cannot give their children permission to commit an armed robbery. Parents cannot give their children permission to burglarize the school after hours, et cetera. So parents cannot give permission for an adult to have sex with their child. Bottom line. To them it is very, very black and white, and they really tend not to worry about these inconsistencies. But you also see these kinds of inconsistencies in the law between the family court and the criminal court in the area of child support. And this particularly comes up when we're talking about young men who are the victims of statutory rape with an older female. If that older female files for child support, the young man is brought in and is held to pay child support until the child which he sired becomes 18. And this is true even though the young man in criminal court is declared to be the victim who had no competency whatsoever to choose to have sex in this circumstance. Family court doesn't care. Family court says, if you factually consented, you're on the hook for producing this child. And again, prosecutors do not seem concerned about those inconsistencies. They have a very strong ability to segment parts of the law and to say, this is our responsibility, that's theirs, and we'll leave it to the legislatures to clean it up. Thank you.
Well, thank you, Professor Levine, for vindicating your sterling reputation as a learned scholar of the criminal law, and particularly of this area of deep, difficult social, cultural, and moral impasse. And I think she deserves another round of applause for this display. Well done. Thank you as well for vindicating the highest purposes of our Family Forum series, which is to engage you in earnest conversation about cardinal issues of politics, of society, of law. May I invite you to continue the conversation with Professor Levine after the fact in the foyer. May I also invite you to come back on Monday, April 11, when the provost of Emory University, Earl Lewis, will be here to talk about the Grutter versus Bollinger case, the most recent affirmative action case that the United States Supreme Court has ruled on, and he will bring an insider's view, because he at the time was dean of the Graduate School of Arts and Sciences at the University of Michigan and intimately involved in the policy that was under discussion and ultimately under dispute. We would welcome you to come back to this forum on April 11th for that. All the fora in this Family Forum series have been videotaped and are available on our center website, and you can see that in the program before you. And I would commend to you, if you have colleagues or friends or students or others that should see the program today, please just punch onto the website and you can see a downloaded version of it, or you can also, after the fact, buy a DVD, which we'll have available to you at cost to us and therefore cost to you. May I invite you, when you're looking at your program, to see there's a little blue card. That blue card will indicate to us where you heard about this information. Some of you are students that have been conscripted to be here. You don't have to fill in the card. But others of you that are not conscriptees, it would be very helpful for us to know how you heard about this forum so that we can be more effective in the advertisement of future events and drawing in additional parties. May I also ask you to join me in thanking my colleagues in the center and our friends in the AV program at Emory for all the work that they did in putting together this forum and other forums that are part of this Family Forum series. These are folks that are often working relentlessly behind the scenes, do not often get recognized, and I think it would only be right to recognize them with a robust round of applause. Thank you very much for coming. Please join us for light refreshments, and thank you, Professor Levine.
The preceding program is copyrighted by Emory University.